have you heard anything from anybody that I started with on their tests and anything?
On their tests, virtually everybody who's taken the last couple of weeks has passed it.
Really?
And everybody's getting in the 80s and 90s on it.
Oh my
So,
gosh. Like all of the guys that I started with?
yeah, everyone that I've heard from. Yeah,
That's
make sure you
awesome.
come and tell me, guys, when you pass it, okay?
Yeah.
So even if you don't pass, come talk to me. Let's get you through this. So you worked too hard on this. But remember, our number one rule: one and done. That's it.
And done.
Yep.
What about Maxine?
Haven't heard from
Aw.
Maxine, so I don't know
Okay.
what she's doing. So, but she hit us down real well.
And the brother and sister?
They haven't taken it yet.
Okay.
Yeah, that I know of. I don't think they have. So,
And what about these guys, Kyle and Kyle?
Kyle was going to take it, I believe, yesterday.
Okay.
So, and he was taking the afternoon, so he couldn't come in and say hello. So, said he passed
And
it.
then his buddy?
Yeah. As far as I know, he did take it past it. So,
That's so cool.
both of them.
That makes me excited.
Yeah. So anyway, guys, yeah, it's it's a very tough test.
Yeah.
I'm not going to soft soap it. It's going to take 110% effort to get through this and pass that test. Remember, the purpose of that test is to keep you out of real estate, not to introduce you to real estate, but to keep you out. So, okay, let's look at liens. Now we're going to talk about taxes. Yesterday we talked about foreclosures. Hopefully you feel comfortable with foreclosures. They are a part of our industry that you need to be pretty well versed on. Now we're going to talk about taxes. And when you get done with this part of the course, you're going to know quite a bit about how taxes are handled in Colorado. You should be really one of the experts on it. Well, you know everything there is to know about taxes? Nobody does. Yeah, they talk about taking your taxes and giving to 10 different CPAs, and they come back with 10 different figures. So when it comes to taxes, it's a very, very deep subject. But we're talking about how we actually assess properties for tax purposes. And you should be very well versed on that by the time we get through. So let's look at taxes and assessment. Actually, right above it, the introduction, top of page 1832, there's two types of liens. Specific lien, that'd be specifically against your house. And then a general lien, which would be judicial, it's through the courts. A general lien and a judgment are the same thing. And a judgment encumbers everything you have. They can garnish your wages, they can sell your furniture. It's nothing to take lightly. So again, a specific lien and a general lien. If you have a general lien, you can't buy a house, as an example. So let's look at taxes and assessments here. Property taxes, special assessments, and water and sewer charges levied by law rather than usage become a specific lien on specific realty, specific property to which they pertain. The taxing body, usually the city or county, may take action resulting in the sale of a property if these charges are not paid. Property is subject to general, and our taxes are called ad valorem taxes. That's Latin for according to value. And every property has ad valorem taxes. Property subject to ad valorem property tax is assessed on January 1st each year for the previous year. So what days are taxes due? January 1st. When are the taxes for 2015 due? January 1st, 2016. January 1st for the previous year. And a lien for the tax attaches on the same day. You couldn't pay your taxes on January 1st if you wanted to. It's a holiday. On page 1832. Okay. And so everybody, taxes are paid in arrears. Everybody who buys a home in Colorado has an unrecorded tax lien on their property. You couldn't pay your taxes for this year when you closed if you wanted to, because they're not due until the end of the year. So again, every property that closes in Colorado has an unrecorded tax lien on it. And a lien for the tax attaches on the same day, January 1st. Property taxes are perpetual lien upon the real estate until paid, including penalties, charges, and interest that may accrue. Property tax liens have priority over all other liens, regardless of filing date. Real property taxes may be paid as follows. Big star by this. one half on or before the last day of February, and the remaining one half on or before June 15th, or the entire tax may be paid on or before the last day of April. Well, I think I got caught up in this. Is lesson 9, by the way. I'm recording, guys. I forgot to say it's lesson 9 we're looking at today. As soon as the first one half installment becomes delinquent, March 1st, interest penalty accrues until the date of the payment. Now, let's talk about this. First of all, how can we pay our taxes? Let's read that paragraph before that again. Real estate property taxes may be paid as follows. One half on or before the last day of February, and the remaining one half on or before June 15th, or the entire tax may be paid on or before the last day of April. So, two different questions. How are taxes paid in Colorado? They're paid in arrears. What day are they due? January 1st. How are they payable? You can pay half on the last day of February, the other half on June 15th, or the whole amount on April 30th. When are all unpaid taxes delinquent? June 16th. Some of them are delinquent March 1st. That's a question on the state exam. They're going to try to trip you up with it. Let's run through this. Let's say you don't make your last day of February payment. And then April 30th comes and you don't make that payment. They're going to start assessing you penalty back to March 1st. Everybody see that? Because you didn't make that half payment on the last day of February. So your interest and penalties will start accruing on April 1st. Any questions on that? But all unpaid taxes become delinquent on June 16th. Now, let's run down this page. Let's run down a couple sentences there on the right-hand side. For the single payment option, interest accrues as of May 1st. On June 16th, all unpaid taxes for the preceding year become delinquent, and the interest penalty will be assessed in addition to any previous penalty that has accrued. Expect to see that question. When do all unpaid taxes become delinquent? June 16th. If you don't make that first payment and April 30th happens and you don't pay the whole amount, your interest will start accruing March 1st. Look at the last paragraph on this page. The county assessor, publicly elected in 62 counties and appointed in the city and county of Denver, determines the assessed valuation of the property. The valuation for assessment of all taxable residential properties determined by statute and is 9.35% of its actual value and 29% for commercial and raw land. So, every property in Colorado, whether it's in Aspen or Commerce City or whatever, is assessed the same. It's assessed for the same amount. It's assessed at 9.35%. And that's for 1 to 4 unit properties. Commercial properties and vacant land are assessed at 3 times that amount. 3 times that amount. Pretty wild. So, one time I was on my way to this funeral, and I was listening to Mike Rosen on KOA. And somebody was called up and said, yeah, he said, I got a piece of raw land that's worth the same as my house, and my tax on my raw land is 3 times more than my house. And Mike Rosen said, oh, that can't be. And the governor said, no, that can't be either. The governor didn't know this, guys. And so would somebody come in and try to straighten this out? And I tried to call and couldn't get through. But several people called, and everything they said was wrong. And then I finally had to go into the funeral. So I don't know what happened with that. But anyway, the point is, it's something that once you know this and understand this, you can explain it to people, and there's not a whole lot of people who know this. So, the next paragraph here talks about something called a mill levy. It says 1/1000th, blah, blah. Don't think of it that way. A mill is 1/10 of 1%. There's 10 mills in 1%. 10 mills in 1%. So let's run through this. We have this property we have this property. My phone's turned off here. We have this property that's worth $200,000. This $200,000 is either market value or market price. If it's market value, it's because of one of the assessors for that county who works for the county went out and assessed that property at $200,000. And that's what they're going to use for your taxes. Or it could be market price. Maybe it's sold in the last 6 months. So that's what they're going to base the value on to begin with, what it sold in the last 6 months. Between market value and market price, which one is going to be more accurate, typically?
Price.
Market price, yeah. That's where somebody put their money where their mouth is and said, yes, I'll pay $200,000 for this property, and actually did it. That has more weight than an appraisal. When we talk about appraisals, we'll spend a whole day on appraisal in this course. But what an appraisal is really just a wag. It's a wild ass guess, is what it is. But hopefully it's an educated wild ass guess. And that's what an appraiser is doing. It's an educated guess on this property. And so they're going to use one of those two figures, either the assessed value that the assessors who work for the county went out and said this home is worth this, or market price, what it sold for. Then they're going to hit it with the assessment ratio, 9.35%. 9.35%. So what's the assessed value of the property? Help me out here. 200,000 times 9.35%. I could do in my head, but I don't want to think that hard this morning.
18,700.
18,700. Sounds right. We have market value or market price times the assessment ratio, which gives us our assessed value. Then we take that assessed value and hit it with a mill levy. Now, what if they say that this particular property has 20 mills? What are you going to multiply that by? If it says it has 20 mills.
2%.
2%, because there's 10 mills in every percent, right? What if they say it's 40 mills? 4%. 4%. What if they say it's 5%? How many mills?
50.
50. Who's lost on this? Who's lying? Everybody cool? Okay. 10 mills to 1%.
Oh my God.
Don't overthink it, guys. The problem with this course is that you tend to overthink things.
Yeah.
And it just, take it down to its lowest denominator. We have an election coming up. And what will happen is you might hear them saying, if you vote this through, this RTD tax or whatever, your sales taxes on your food and everything are going to go up 4 mils. What does that mean?
0.4%.
Yeah, your sales tax is going to go up 0.4%. How many people do you think know that? Nobody. But you guys do. Now you can even vote intelligently, knowing what a mill is. So this is again how we start off: market value or market price times an assessment ratio, which gives us our assessed value. We multiply that by our mill levy, whatever that is. Let's say it's 60 mills, 6%. Okay, and that would give us what the actual taxes on that property are. Every odd year in Colorado is an assessment year. So 2015 was an assessment year. And in February or March, you all got this statement from the government, from your county, saying, this is how your taxes are. This is not a bill. It says that several times on there. Because what? The banks send this out. We don't write a check and send it in. The banks take care of this for us if we have our escrows. Because we make our payments. How do we make that payments? What's that called? PI. TI, principal, interest, taxes, and insurance. And so they break it down and say, this is how we came up with how much taxes you owe. If you can find that sheet, if you own a house, you got one this year, in February or March, go back and get that and look at it. You're going to see this right like this. Pretty cool. Pretty cool. And when you're working with your clientele, you might, and they have all their paperwork out, you say, can you have all your paperwork when you go list their home? You can go through this and you can get that sheet of paper out that they got from the county last year, or the year before, whatever, and go right down the line and tell them what that is. How cool would that be? So again, keeping yourself above the crowd. Now, a county board of equalization. Now this is wild. Any questions? Any questions on this? Can I erase this?
But the 6% is the mill.
The 6% in this case would be the mill levy for that area. So it was 60 mills. I'm just throwing that out there. Whatever that would be.
Can you name each one? So the 2% is the market value and the 9%.
Yes. Let's go down it again. This is the assessed value or market price. Either market value or market price. If it's sold in the last year or 6 months, they might go just off of this market price. Or if it hasn't sold, they're going to do an assessment on it and come up with again a market value. On the state exam it says who determines market value?
County assessment.
Market.
No, who determines market value?
The
Market.
Market.
Who?
Sorry.
The appraiser.
Appraiser.
What
Okay.
determines?
Two different words, guys. Two different words. I'm glad we're struggling with it so you can get it because you're going to see it on the state exam. Who determines market value? The appraiser. What determines market value? The market. The market itself. And the appraiser just interprets that market value. So this is market value or market price times our assessment ratio, 9.35%. If it's vacant land or commercial, you're going to multiply that sucker by 29%. And that gives us our assessed value. We multiply that by the mill levy for that county, and that gives us our taxes. So that's how we come up with our taxes on these properties. And what happens, can I erase this now? Everybody got this? And understand it. And I can say that again real easy. Everybody's comfortable with that. If you came up here and sat here, you could say what I just said, right?
So where do you get the mill levy from?
Every county will have that.
And
Like-
it's stated. Okay.
Yeah, and every county's different. So what they're going to do, they're going to, when they send you that sheet of paper in February, March, they'll break down what your mill levy is for your county.
Okay.
Remember, the county is the one who has your ad valorem taxes. Then, of course, you have your sales taxes on the stuff you buy. That goes to the cities. So that's how that works. Okay, now, equalization, Board of Equalization, and this happens. It's upsetting to even talk about it, but what happens, let's say, and I'm just using this as an example, let's say Adams County looks at their 2,000 square foot homes, and they say our 2,000 square foot homes are going for $200,000, where Jefferson County's 2,000 square foot homes are going for $300,000. Let's do an equalization factor and make our 2,000 square foot homes the same value as they are in Jefferson County for tax purposes. And again, that's a Board of Equalization that'll do that sometimes. So again,
That's legal.
just, yeah, is it legal? Sure. They're the government, of course it's legal.
They do that to get more taxes.
Sure, to get more taxes, yeah. And I'm exaggerating, they wouldn't go to this extreme, okay? But pretty close. And they would do something like that. And again, it's an equalization factor. And what happens when you get that assessment in the mail in February or March?
You argue.
In Colorado you have 30 days to fight it. It sounds like a short amount of time. In Kansas it's 10 days. Colorado is one of the longest times, 30 days. And that didn't sound like much. But we're all hypocrites. We say, oh, look at how much they think my home is worth. I'm going to go down and fight them. But when it comes to putting it on the
Selling
market,
it.
we go, my home's worth this much. I'm so proud of it. It's human nature, But again, do you want to go down and fight it? You have to have such a difference in what you think it is and what they think it is. This figure here, that 200,000 figure, you've got to figure that has got to be a huge amount more than what it really is. Because essentially, you go down and fight it yourself, but you pretty much need an appraiser who can go down there and really go talk to them. And I've been down to this, more than once, to say the least, where people would hire me to do it, and they go down there with them. And what I do, I'll charge them $400 for the appraisal and $450 an hour to go do this. It's not cheap to do this, so it's got to be worth your while. But when you walk in there, it's kind of interesting because they have the county assessor and and a bunch of his assessors are there, and they try to keep it really light because everybody walks in there is really upset because their taxes are too high. They come in hollering and screaming, and everybody, they make it jovial and they laugh and everything. They really try to keep it way down paced, and they're pretty darn good at it. And so you go in there and you don't get into a big shouting match with them. They look at it and they take into consideration what you have to say. And most of the time, if you show up with an appraiser, I've hired many assessors when I had my company, appraisal company, and every one of them I hired, I had to untrain them and train them how to do a single family home. They could do 100 homes like this, but one home, totally lost. And it got to the point, unless they had been in the regular market before they became an assessor. But it's a completely different ballgame how they look at properties. And when you come in there with an appraiser saying, yes, this is what this one house is worth, they'll usually just go ahead and go with that value. But like I say, it's got to be considerable or it's not going to be worth the money to do it. So, look at that last paragraph. Before the first day of September of each year, county treasurers notify delinquent taxpayers by mail of the amount of delinquency and penalty interest thereon, and afford 15 days from the time of mailing the said notice to pay the tax. Treasurers then make a list of all the county lands with delinquent taxes, publish the list, and designate the date for public sale. If such a list is made later than September 1st, a sale held under that list is still valid. Delinquent sales tax sales commence on or before the second day of December of each year and are held at the treasurer's office in each county. Such property is sold to the person who pays the delinquent taxes, penalty, interest, and costs due, and who further pays the highest bid over these amounts in cash. The owner or agent or assignee may redeem real property sold for taxes at any time before the issuance of the treasurer's deed. The person redeeming must pay to the county treasurer the amount for which the property was sold, together with interest from the date of sale. And the county assessor issues a certificate of purchase. Remember, we talked about that yesterday, last session, when we were talking about when you buy a property at a trustee sale, that day you get the same thing, a certificate of purchase. Certificate of purchase. You don't get a deed that day. You get a certificate showing you that you got the winning bid. County treasurer issues a certificate of purchase to a high bidder at the tax sale. A certificate of purchase is assignable, and if the property has not been redeemed, the certificate holder may request the treasurer to give notice of the sale to every person in actual possession or occupancy of the property, to the person in whose name the property was taxed, and to publish such notice. After notice and publication, the treasurer will issue a treasurer's deed to the holder's certificate of purchase. How many times did I ask you last session, what kind of deed do you get in a tax sale? A treasurer's deed. And that's just a fancy name for a quitclaim deed. After the treasurer's deed is issued, executed, delivered, and recorded, it is presumed to be validly acknowledged. What's acknowledged mean? Notarized. After the deed has been recorded for 5 years, 9 years, if the delinquent owner is legally disabled at the time the deed was issued, the delinquent taxpayer has no legal course by which to recover the land. A holder of a treasurer's deed may initiate a quiet title suit in order to acquire marketable or merchantable title before the expiration of the 5 or 9 year period. So, They have 5 years to redeem, 9 years if the person who lost it was disabled. That's why if you pay the taxes for 7 years, you can get that property. It's halfway between the 5 and the 9. And again, if I buy this property at a tax sale and I don't pay the taxes on it, they're going to foreclose on me with a tax sale. So again, knowing how to play the game. And in Colorado, you're not going to get a house at a tax sale if there's a lien on it of any kind. I have a $200,000 lien on your property. I'm going to let you walk away with it for $2,000 in late in back taxes. Not going to happen. You might get some vacant land at a tax sale and be able to keep it. And there's some nice land. You can, you know, up in the mountains and whatever. There's some nice land around that you can get at a tax sale. But generally speaking, you're not going to get a house unless there was no lien on that house. Now, let's look down at the mechanics liens. And what's a mechanics lien? That's a contractor's lien. First of all, you pay the guy or the lady who's coming out to do the work, and he has to first pay, look at that 1, 2, and 3 at the bottom of that page, 1834. First liens of laborers or mechanics. So you pay your laborers first, then your suppliers, then you pay yourself. And if you pay this contractor and they don't pay their subcontractors or suppliers, then they could sue you and you could end up paying it twice. It happens every day. It happens every day. So you have to be very diligent about this. When they come over, they're going to re-pour your driveway, or they're going to sod your lawn, let's say, whatever. They're going to paint your house, put a new roof on your house, whatever. And they show up, how much have you paid them at that point? If you're smart, nothing. If you're smart, nothing. If you paid them half, you're what? Stupid. Really. And so what you say is, you know, I'll give you, so you have to get your materials and everything, and usually it's an insurance deal, whatever. You give them maybe 25% of it, so they can go ahead and get the shingles and everything that they need to get going. And then pay them, when you get, and once you start, you get 25% of it done, then I'll give you another 25%. And then when they get that done, you ask the laborers, make sure they're being paid. Call up Home Depot or wherever, make sure they've been paid. And if not, then you don't give them any more money. Make sure you're on top of this. Do your own due diligence. Look at that third paragraph on page 1835. No mechanics lien shall hold a property longer than 6 months after the last work is performed or materials furnished, or completion of the improvements, unless a lawsuit is brought within that time to enforce the lien, and unless a notice stating that such action has been commenced shall have been recorded within that time in the county clerk and recorder's office. So, let's say you don't pay this contractor for some reason. They can then come after you with a mechanics lien, and they'll put it against your property, but you can only hold your property for 6 months. Morning. Unless within that 6 months you file a lawsuit against them. And of course that's in county court, unfortunately, and it's kind of like the foreclosures worked. It takes about 2 years to get in court and costs about $10,000. So the typical small contractor is probably not going to come back and sue you. But the bigger contractors, they're not going to mess around. They're going to come after you. They're going to make sure they get paid. And again, any mechanics lien can only hold that property for 6 months, unless during that 6 months you do get file a lawsuit against them. Now, the thing to remember, this may help you. If the amount is under $7,500, you can take them to small claims court, which is the people's court. You can get in right away, and it cuts the expenses down tremendously. So let's say you have a $14,000 job that you're doing as a contractor or whatever. Break it into two $7,000 bills so that you can go straight to small claims court on both of those if you need to. But the first thing the judge is going to tell you when you start doing that is even if you win, it's up to you to collect. And it's pretty tough to collect sometimes. So make sure you're on top of that. And look at that 6th paragraph right above the Vendees lien. Let's read this. Funds dispersed to a contractor in accordance with the contract are declared to be in trust for the payment of subcontractors, material suppliers, and laborers, except for good faith differences of opinion or the existence of performance bonds, wrongful expenditures of these funds constitute the crime of theft. So you pay this contractor and he doesn't pay his people, doesn't pay the suppliers, you can get theft charges against them. If what? You can find them.
Oh.
That's usually the biggie. So again, when you're working with contractors, make sure you're being very diligent. You're using your head. Make sure you do your due diligence, for sure. And then we have vendees lien and vendors liens. Those are the type of liens we have and an owner will carry. And do you need to know a lot about those? No, just know that they exist. And also an attachment. Now, for the purposes of the Colorado exam, an attachment is a lien. You know, attachment is also a fixture. You attach that chandelier. That's now an attachment. But for the purposes of the state exam, an attachment is a lien. I'm going to sue this guy, and all of his assets are in his house. I'm going to ask the court to attach his house so that he can't sell it until after the court date comes to pass. So an attachment is a lien. Let's go over to the next page, 1836, second to last paragraph there, top of the page, second paragraph talks about that lis pendens again. A lien pending, an action pending. And yeah, you're going to have a question about that on the state exam to some extent. Like I say, we don't have a lot of lis pendens in Colorado because they have to be filed judicially. And then we have fraudulent liens. We've talked about this in the past. This is known as the Winchell-Spurious lien statute. Winchell, just like the donuts, W-I-N-C-H-E-L-L. Spurious, S-P-U-R-I-U-S. I-O-U, yes, actually, S-P-U-R-I-O-U-S, spurious lien statute. In other words, it has to be a legitimate lien on that property, or there could be serious consequences, including going to jail. And remember, if they don't pay us, if the people don't pay us for selling their home or whatever, we cannot put a lien on that property. Either can appraisers, or inspectors, or lenders, or title people. The only people who can put a lien on it are surveyors for some crazy reason. So again, the Winchell-Spurious lien statute. Look at the second to last paragraph down there. It talks about, what if I have an IRS lien against my property? An IRS lien. Where does that fall in? That's a government lien, but it only falls in from the date it was recorded. It doesn't go to the top of the list. It only goes to the day of recording. This falls in there for an IRS lien. Now, look on the second paragraph on page 37. State tax liens. Let's read this. Like the federal government, Colorado may also acquire liens against real property for the non-payment of state income taxes. What's state income tax in Colorado? 4.5% we have to pay to the state of Colorado. And a lien for delinquent state income tax becomes a lien upon the taxpayer's real property, because it's a judgment. And this lien priority is established by date of filing and continues for 6 years unless it's paid. Judgments typically last for 6 years, then they have to be reinstated. Then we have the decedent's debts. This is a death tax. George Bush got rid of that in 2005, and Obama reinitiated it for 2012. And this is like, you have a farm where it's been in the family for 150 years, then the parents die and the kids get it and they have to sell the farm in order to pay the taxes on it. So that's what they're trying to get rid of get rid of, and it did happen for years, but it's back on the books again. So, chapter 19. Now let's stop right there. How about this? I hit you with a lot of stuff on this tag. A lot of good information there. Did you see how well it was explained? You know, anybody can read those pages and understand it. There's no legal jargon in it or any of that. Any questions on that? Any questions on that? Let's run through the whole scenario here. First of all, you get behind in your house payments. What will that trigger?
Oh,
Acceleration.
An acceleration clause. An acceleration clause triggers a notice of election and demand, an NED. And an NED triggers a foreclosure. And what are the two types of properties in a foreclosure action?
Agriculture and
Agricultural and non-agricultural. What is that period called before the sale? The redemption period. What's it called? Before the sale is the equitable. The equitable. What is it after the sale? Statutory, which we don't have in Colorado anymore. We do with property taxes, yes. Well, let's keep going. So, we have it, the property taxes on this property. And of course, what are these property taxes called?
ad valorem.
Ad valorem taxes. On a sale in a foreclosure, what is the dates for an agricultural property that they'll sell it?
215 to 230.
215 to 230. 215 to 230, guys. And how much for non-agricultural?
125.
110 to 125. 110 to 125. Then they will sell it. Okay? Now, how are taxes in Colorado paid? In arrears or advance? In arrears. And what day are they due?
January 1st.
January 1st they're due. And how are they payable? Half
Half the last day of February.
last day of February, the other half on June 15th, or the whole amount April 30th. And when do all unpaid taxes become delinquent? June 16th. And just not for the state exam, but just to know this, what's the assessment?
sorry.
Good morning. What's the assessment ratio in Colorado?
9.3.
9.35% for 1 to 4 unit residential. And what is it for vacant land and commercial? 29. I feel like making an entrance. Okay, guys. Chapter 19 is the closings. We'll go over that when we hit closings. Chapter 20 is escrow accounts. We'll spend a day on escrow accounts. So, we'll put those two chapters on hold for now, and let's go to chapter 21. And this is one of the more interesting parts of the entire course, is how we handle rental properties and how to work with landlords and landlords working with their tenants also. Why don't we go ahead, let's go ahead and take a 5-minute break. 5 minutes. Okay, let's continue. We're on page 21-1, talking about property management. And let's go to the second to last paragraph on that page. Second to last paragraph where it says, occasionally employed brokers are tempted to perform residential property management without their employing broker's knowledge or consent. An employing broker is prohibited from performing residential property management outside of the knowledge and supervision of his or her employing broker. Section of the state statute requires all business to be conducted only in the licensed name of the employing broker. And the employing broker must be aware of their employed broker's activities, supervise all employed broker's activities, and maintain proper accounting of any monies obtained by the employed broker in accordance with Rule E1 and the other state statutes. Further, the employing broker should have a clearly written policy as to the firm's offering of management services and outline specifically how the firm and its employees will conduct such service. Maybe you're working on your own properties, and all of a sudden one of the neighbors says, would you like to kind of take over mine and manage it for me? I'll pay you 10% of the income, whatever. You say, oh, sure. and pretty soon you're taking that over, maybe your other next door neighbor, whatever, and you don't tell your broker because you're just doing it. And obviously, it didn't even enter your mind to tell your broker that you're doing that, because now, if you're doing just your own properties, that's different. But you start doing other people's properties, and your broker needs to know about it.
So that only applies to other people's properties, not your own.
No, not your own. Yeah, other people's property, not your own. Yeah, once you're doing your own, that's none of your broker's business. That's your own properties. But you start doing any property management with anybody, and you've got to let them know.
What if the property's shared ownership, meaning some third party?
With you and someone else as the third party, well, it usually is. But you're one of the owners.
If I own the property with someone else,
Mhm.
I can still manage it myself.
Sure, you
Don't-
bet. Yeah, even if you're just and usually very seldom you own it all together. Usually it's you and your husband or you and somebody else. But yeah, that would not fall into that category. Top of the next page. Property managers face challenges of aging construction, cash flow requirements, vacancy rates, heating and cooling concerns, and electrical and plumbing needs, as well as EPA guidelines for radon, asbestos, and lead-based paint, plus both federal and state fair housing and civil rights regulations, and the state-mandated warrant of habitability and carbon monoxide detector requirements. Additionally, sound management and accounting practices must be followed to avoid commingling of funds among the properties managed. Remember that carbon monoxide? Tell me about it. What,
It'll be 15 feet.
within
Every
15
bedroom?
feet of all bedrooms,
Oh, I thought
upstairs
in each
and
bedroom,
down.
no?
Pardon me?
I thought it was in each bedroom, but no.
No, within 15 feet. So like on a two-story, a lot of times there's 4 bedrooms up on the main level. Just put one up there. That'll take care of all 4 of them. So, typically, anyway. And next paragraph, professional property managers perform a variety of functions and must be able to advise on heating, cooling, painting, decorating, roofs, pests, insurance, the sales market, and household appliances, and must know when to refer to other professionals such as financial or tax advisors or attorneys. And property managers should be adept at problem resolution, negotiations, accounting, budgeting, and sales. A working knowledge of the landlord-tenant law, access to a competent attorney, effective communication skills, and the ability to organize and delegate effectively, as well as good time management skills, and I love it, stress reduction techniques, are also necessary for efficient property management. While an average sales licensee may handle 2 or 3 transactions a month, a professional property manager with an inventory of 200 units may be executing 5 to 6 leases, as well as collecting and dispersing income from all 200 units every month. The dollar value of each transaction may be smaller, but the manager is most often responsible for the entire value of the property and over an extensive period of time. The skills involved are equally important. A homeowners association manager may handle 1,000 units comprised of many small or several large communities. At the outset, a property manager must clearly understand the owner's needs and desires for the property. Management plans must support the owner's objectives of short or long-term ownership, long-term investment, or other income needs. As the management contract continues over time, the manager must excel in clear and prompt communication with the owner. The property manager may decide to specialize in a particular type of property or to service many types. Property management specialties may include single-family homes, attached or detached, condos, townhomes, multi-unit buildings, residential or office, government-assisted housing, retail properties, shopping centers, office or industrial complexes, resort or short-term rental properties, and homeowners associations. And that's not a complete list, but pretty close. That's where you get your business for the most part. Now, I tell the story about a call I got a few years back from a friend of mine. She called me out of the clear blue. I hadn't talked to her for probably about 9 months. And she called up and said, I just want to give you a call and just tell you I'm leaving, say goodbye. I said, "Why, what's going on?" She said, she got a job managing a resort on the South Island of New Zealand. And she was leaving the next day. And I guess they flew her out there 3 times to make sure it was a good fit and this and that. When I knew her, she was a secretary down at Pepsi downtown. She hadn't worked a day of real estate in her life. And here she's got this on the table, and I thought, I've been doing this forever, and I've never had an offer like that. Anyway, and she left the next morning. This several years ago. I haven't heard a thing from her. I hope she's doing real well. But again, there's jobs like that out there too, guys. Once you get your license, where
It's hard to get a working permit there in New Zealand.
No, I was just gonna say that there's an apartment community that was hiring a property manager,
Mm-hmm.
and I have a lot of experience in property management, and I told her that I was getting my real estate license, and she's like, "Oh no, that's a conflict of interest."
What?
Yeah, yesterday, the boulders. in there.
Conflict of interest
She's like, "You can't have your real estate license."
and do what?
And be a
their
property
manager.
No, that's not true. You can't sell.
That's
They might want you to pull it if you were selling properties, but
Yeah, you have to be licensed to be a property manager. It's the
No, you
law.
she's
It's
confused.
not.
Yes, you do. You
Well, then
have
maybe
to
you
be
should work
licensed.
there.
You have to be
What
licensed.
license are you talking about?
You have to have a real estate license to be a property manager.
Not if you work under a property management company, you don't.
Yes, you do. Now, if the property if you're working for the owner of the building, and they have their own property management company, then
That's
you
what I'm
don't.
talking about.
Then you don't.
Yeah.
Okay.
Yeah.
But that's a very small window. For the most part, to be a property manager, you do have to be licensed. Now, to be the manager of a homeowners association,
That's totally different.
they have a new license that they came out with that you have to get. And there's over 8,700 homeowners associations in Colorado. Over 8,700. How many are there in Florida and Texas and California? Wow. But in Colorado, to manage any of these homeowners associations, you have to have this new Community Association Manager, a CAM license it's called. You don't need to have a real estate license, but you need to have this CAM license to be the manager of a homeowners association. And the Real Estate Commission doesn't know if there's 1,500 people need this or 5,000 people need this license. And you had to have it by July 1st of 2015. And as of July 1st of 2015, less than 500 people have passed that test to get their license. Most property managers don't know that they need
yeah,
this.
so they're doing it, but it's not,
they're
not
doing it.
legal.
And what happened is the Real Estate Commission on July 2nd sent out all these flyers to everybody, all the real estate companies, all the homeowner associations, everything, and they said this license was supposed to be yesterday, and if your manager of your association does not have this license, then all of your contracts are void. And you're looking at lawsuits, you're looking at possible criminal charges and blah blah blah. So they're making a big deal out of this. Again, you do not need your real estate license to be a manager of a homeowners association, but that's going to change too. The Real Estate Commission within the next year or two will make it a requirement to have a real estate license to do these also. What does that mean to you guys? What an opportunity if you wanted to get into this and get this license for right now and get into this where you're managing a homeowners association, and then in a year or two when they require you to be licensed real estate broker, you're going to be solid gold out there for these properties. So I'm just throwing that out there, another way to make a living.
And how many
In
hours
this
is that?
Yeah.
And this class is only 24 hours. Then you go take a state exam. Like this class here is 168 hours. This CAM class is only 24 hours, and we do it here. There's only 3 schools that do it. And we do it on Friday and Saturday for 6 hours each day. And our cost on it, $450, and for you guys being students, we give you a 10% discount on that. So works out to, rounded off $400, and that includes all your materials and everything. So I'm just throwing that out there. I know last class we had last month, a couple people in that class jumped in to this class also. And it's a lot of redundancy, a lot that you already have in this part of the course, but it really brings it to another level. Remember we talked about homeowners assessments, and what are they? The names of them, homeowners dues, CC&Rs, covenants, conditions, and
yeah.
restrictions, governing documents, deed restrictions, and all these things. For us as real estate brokers, they're all the same thing. For a property manager, they're not. And so it just kind of breaks it down into what those are and what the responsibilities of keeping them up are and things like this. The course is interesting, a lot of information that feeds more information on what you're taking here. It's not like you're walking in there knowing nothing and having to do this, which some people are, but you guys you know this stuff pretty much. You're just getting more added onto it. But I'm just throwing that out there. If anybody's interested in doing that, the door is really open right now for you to jump in and possibly make that your career in real estate, in property management, managing these homeowners associations, and there's darn good money in it too. So, and this, like my friend going to this thing in the South Island of New Zealand, whatever, and there's deals like that out there. I tell the story about 10 years ago or so when Mexico required all of their people selling timeshares to be licensed, and I had some of them come up here and get licensed. And talking to these guys, I tell you what a great way to spend a few years of your life. They go all over the world, the French Riviera, the South America,
It's
Belize.
kind of a shady business, though,
It's a tough business. It's a hard sell business, whatever. But I tell you, but they said
don't have the ethics courses that
ethics-
we have to take.
well, that's why they had to get them licensed. That's why Mexico required it to be licensed. But you can also do timeshares here. Vail, Aspen, there's places. I'm just, again, another income opportunity. So, anyway, the Wyndham Hotel, I think I told that story too, where they had an office here in Broomfield and one in Arapahoe County, and they called me up and they said, we need people for Mexico, and we have a contract now for 1 year for $250,000 guarantee, but you have to speak Spanish. And I don't know if there's deals like that out there or not, but son of a gun, call some of these resort areas and say, you're bilingual, you're gold to these people. Man, oh man, use it.
I've been like a manager, manager for like 2 years over there in the outlets of Silverthorne.
Uh-huh.
And I would say like every winter time, I would say like 70% of all the customers are people from Mexico. But the ones that they live in Mexico and they have a lot of money. So when they buy over there, they buy like $500, $700, $800, $1,000, in clothes. So, and those are the ones that buy, timeshares over there in like Breckenridge. They go to ski, like in Vail, Beaver Creek. They don't go to Keystone, they don't go, because I think for them, like Keystone Resort and Breckenridge Resort are cheap. So they go to Vail or Beaver Creek, that's it, that's where they go.
Really? Well, if you're running around with that kind of crowd, you might want to look into something like that.
And to be honest, it's crazy because they prefer, to be attended by another like Hispanic person.
Oh, sure they do.
Yeah.
Sure
So,
they do.
Plus
Yeah, they can relate.
Yeah.
If you're
Yeah.
bilingual in this business, man, oh man, you can hit people I can't hit. That they don't want to work with me. And I have had, I had one client one time who spoke no English at all. Their whole family, nobody spoke a word of English. I struggled, say the least. So did they. And of course, to fill out a contract now, you have to have an interpreter there. If English is their second language, there's another income source for you guys who speak Spanish. Where in the office that you're at, say, I speak Spanish, guys, and you have to be the interpreter for them. Not if they don't speak English, but if English is their second language, even though they speak it better than I do. If it's their second language, you have to have an interpreter. So, again, another income stream for you guys who know Spanish. Okay, let's go over to page. Let's go to page 21-9. Talking about security deposits and escrow accounts. And escrow accounts are what? OPM, other people's money. And I cannot have any of my money in there. I have to have enough of my money to
Maintain the account.
maintain. Remember that word maintain. How much of broker's own money can have in the account, enough to maintain the account. They used to have a limit. They used to say you had to have, no more than $100 in there years ago. And what happened is if you had a monthly charge and whatever, and you weren't paying attention, and you got overdrawn, that was considered commingling. So now they say enough to maintain the account. My comfort level is about $300. Where if I get audited by the Real Estate Commission or the IRS, they don't think I'm hiding a bunch of money in there, and yet it's a comfortable figure. So everybody's a little bit different in how they want to handle that. And of course, what I do with every deal I do now, of course, and most brokers do too, they just let the title companies handle all of their escrows. And if you do that, you don't even have to keep your own books on that. So, and the title companies, of course, don't charge you anything to do that. They do charge a fee for the title policy. That's why you have them hold that money, because you're going to order the title through them. Any questions on that? Now that's why I bring these title people in here to talk to you guys too, so you know who to call up when you're working with title people. Let's look at top of page 21-9, Legislative Declaration. The provisions of this Part 1 shall be liberally construed to implement the intent of the General Assembly to ensure the proper administration of security deposits and protect the interest of tenants and landlords. And look at this number 1 here. Normal wear and tear means the deterioration which occurs based upon the use for which the rental unit is intended, without negligence, carelessness, accident, or abuse of the premises or equipment or chattels. What the heck's a chattel?
Chattel is,
Personal property, personal property, personal property, personality, chattel, all mean the same thing. Okay. Or chattels by the tenant or members of his household or their invitees or guests. And a security deposit means any advance or deposit of money regardless of its denomination, the primary function of which is to secure the performance of a rental agreement for residential premises or any part thereof. And then it has return of the security deposit. The landlord shall, within 1 month after the termination of a lease or surrender and acceptance of the premises, whichever occurs less, return to the tenant the full security deposit deposited with the landlord by the tenant, unless the lease agreement specifies a longer period of time, but not to exceed 60 days. Big star by that. How long can a landlord keep the deposit? 1 month or 60 days with an extension. It's not 1 month or 2 months or 30 days or 60 days. 1 month or 60 days. And no security deposit shall be retained to cover normal wear and tear. In the event that actual cause exists for retaining any portion of the security deposit, the landlord shall provide the tenant with a written statement listing the exact reasons for the retention of any portion of the security deposit. When the statement is delivered, it shall be accompanied by payment of the difference between any sum deposited and the amount retained. The landlord is deemed to have complied with this section by mailing the statement and any payment required to the last known address of the tenant. And nothing in this section shall preclude the landlord from retaining the security deposit for non-payment of rent, abandonment of the premises, or non-payment of utility charges, repair work, or cleaning contracted for by the tenant. So you can use that security deposit for his rent if he just bolts on you, if he just leaves. And the failure of a landlord to provide a written statement within the required time specified in subsection 1, remember 1 month or 60 days, of this section shall work a forfeiture of all rights to withhold any portion of the security deposit under this section. So during this time, the guy sends you half your check back, half your deposit, your security deposit back, but doesn't tell you why he kept the other half. He has to give it all back. He has to give it all back.
Trouble? Trouble damages?
No, just all of it back. If again he gave you a portion of it back and didn't say why he kept the rest of it, he has to give it all back to you. Now, let's look at this next part. The willful retention of a security deposit in violation of this section shall render a landlord liable for treble the amount of that portion of the security deposit wrongfully withheld from the tenant, together with reasonable attorney's fees and court costs, except that the tenant has the obligation to give notice to the landlord of his intention to file legal proceedings, a minimum of 7 days prior to filing said action. This is confusing. Let's go over it again. He gives you part of your deposit back and doesn't say why he kept the rest. He has to give it all back to you. If that time goes by and he hasn't given you any of it back and hasn't said why he retained it, he has to give the security deposit back plus treble damages plus 3 times that amount.
Right, but you have to go to litigation to get that done, right?
You're gonna hit him with this and say, yes, I'm going to take you to court on this. And what's going to happen? He's going to say, wow, he's a call up an attorney or whatever. It's going to be small claims court, more than likely. But I mean, this is right in state statute. The guy's going to get stuck with this. He screwed up. He should have said why he kept it.
Well, but he could say he kept it and for a completely unreal, I don't even know what I'm trying to say, but
And that's
they could just say, oh yeah, I kept it because you didn't clean the property, and when you actually did and you left it in better condition, that, you know, they can
sure.
in writing say they kept it for a reason that's...
and you could end up in court, but very few people take the landlord to court because you're usually very young when you're renting. That landlord's very intimidating, and you don't know your rights. Well, let's keep reading here. In any court action brought by a tenant under this section, the landlord shall bear the burden of proving that his withholding a security deposit or any portion of it was not wrongful. So it's up to the landlord to prove that he did it, to prove that he was right in doing what he did. Now, look on page 2111. Second paragraph talks about Boulder. And any security deposit on property that's rented in Boulder, not the city and county of Boulder, we're not talking about Longmont and Loveland, but just in Boulder proper, any security deposit must be paid an interest rate. You have to receive interest on that security deposit. It's the only city in the whole state that has that requirement. I know I'm shocked, I'm sure you all are, that Boulder has something different than everybody else. But yeah, in Boulder, again, and it's not much. I had, anybody renting in Boulder?
I'm renting a property to
Oh, yeah?
people.
You're renting it to people?
Yeah, so
What-
I
what-
didn't realize that I needed to be collecting,
Yeah,
paying
and,
them interest on them.
but it's not much. You know, it was a few years ago, even when everything collapsed and interest rates were nothing, they were requiring like 5 to 7%. I had a lady in my night class, and she's a property manager in Boulder. She said the requirement now is like 0.3%.
3/10?
0.3%. But you might call up Boulder and ask them, because you do have to pay that interest. So,
That's the formula.
yeah. And I had a company call me
Right here. I manage 900 rentals in Boulder through 4-Star Realty.
oh really? Oh, you do?
Yeah.
Oh wow, I didn't know that. So what is the figure?
Well, it depends on when the lease starts. Or actually, no, depends on when the lease was signed. So if it was signed and then it didn't start for 30 days, it's the date of the signature of the lease.
But what's the interest rate though?
It depends on when the lease was signed.
So let's say
Not when you move in, when the lease was signed. It's a whole formula.
it's March 2014.
I got it right here in my email.
What? So is there an
I'll get back to
average? Is there an average that you're looking at up there? Or?
I don't know. Let me look. Because it fluctuates. It really does. If the lease
Really?
was signed in 1980, it's different than if it was signed in
yeah.
Oh well, yeah. And I got a call from this one company who had this one lady who'd been living in the apartment for 18 years, and was moving out. And she said, "I need my interest on all the security deposits." They order like $18,000, something like that.
I returned a security deposit and it was like $500 on top of his security deposit.
Yeah.
Wow.
I have it right here. I really do. I just need to plug in my computer real quick.
Yeah, I like to
Good
know,
to know.
just what I'm talking about. I sound like I know what I'm talking about. You know, so be nice to, and again, like I say, the lady in my night class said it was 0.3%. You know, so it's
It really does fluctuate. It's
And it does
definitely
fluctuate,
not one
okay.
figure.
okay. Well, if you can give us an idea,
Yeah.
that'd be great. Now look at this next part here. A manager should inspect a property prior to occupancy and document the condition of the premises. When the tenant vacates and has caused no damage other than normal wear and tear, the deposit must be returned to the tenant. Now, go back to page 21.9 and look at that definitions toward the top, like the second paragraph there. Look at that number 1 again. What is normal wear and tear? Normal wear and tear means that deterioration which occurs based upon the use for which the rental unit is intended without negligence, carelessness, accident, or abuse of the premises or equipment or chattels by the tenant or member of his household or their invited guests. Which means that normal wear and tear is accepted when you're in a property. It means that the landlord cannot require you to clean the carpet or clean the oven after your lease is over. That's normal wear and tear, and yet that's in every lease. And they get away with it. And you clean all your carpet, and it's never clean enough. And they have to do it again, it's pretty much. But
And then they re-clean it and take it out of your security deposit.
yeah, they will. But again, normal wear and tear. And people don't realize this, that a landlord cannot require you to clean the carpet or, if there's holes in the wall, that's different. That's not normal wear and tear. If there's damage to the carpet or whatever. But just as a matter of course, normal wear and tear is to be expected when you rent a property to somebody. So again,
But if it's written in the lease contract, you're tied to it.
no, it could be for an illegal purpose, because this is state statute. And if they were smart and they wanted to really get you, they can make a copy of this and say, listen, I want my entire deposit back. I'm not going to clean my carpet, not going to clean my oven, and we're going to court, and this is state statute. And let's bring that to another level. What kind of government do we have in the United States?
Democratic.
Is it a democracy? It's a type of democracy. It's a republic. And what a republic is ruled by law. And our courts are not courts of justice, they're courts of law. And the judge is required by the law to make his judgment without his own bias. He has to make his judgment according to the laws of the land. Do they have their own bias come in? Oh yeah, you bet it does. They're not supposed to. So again, if you sue somebody and take them to court for something like this is state statute. And you have to say, Judge, we're a country that we rule by law. And this is the law. How can you possibly rule against me for making me clean my carpet and stuff? So again, you've got rights, and it's interesting how this works. Let's bring this to another level too. Remember we talked about price fixing? And like in your properties, I'm sure both you guys, when you have meetings with other people in the other owners in this subdivision, whatever, or in the area, and you say, how much are you charging? I'm getting $1,300 for my units. Well, shoot, I'm only getting $1,150, and mine are the same as yours. I'm just going to That's price fixing, guys. And it happens all the time when you're, and probably more so in that part of the business than any other part. And they don't do it intentionally, but they're talking to other people about what to charge for their units, and they up it accordingly. Isn't that wild? That's probably about the only place in our industry now where you see price fixing on a regular basis. And these people have no clue that's what they're doing. Yeah.
I just have a quick question. I know I'm sorry, but so every year we get together in a conference room and we have a huge spreadsheet on all of our 900 more properties that we manage, and we see what they're all paying, and we go line by line and we take the market and see if we can increase their rent.
Fair market value.
That's exactly right. That's exactly
that's
right. And what you said you're doing there is borderline price fixing.
Illegal.
It is.
I found that
Isn't that wild?
formula.
Pardon me? Oh, you did find the formula?
Yeah.
What is it? I want to write it
Okay,
down.
so prior to December 5th of 1985, no interest. So I guess it started in 1985.
So before 85, no interest. Okay.
And then, so it's a whole thing. It's 12/5/1985 through 3/18 of 2004. It's 5.5%.
Well, hold on. Before 85, there's 1985, no interest.
Mm-hmm.
Okay, then
12/5 of 1985 through-
12.5 of 85,
Yeah,
okay.
cause it started 12/5 of 85
Uh-huh.
through 3/18 of 2004,
3/18 of 2004, okay.
5.5%.
5.5.
5%,
5.5?
that's a lot.
It is a lot. Anyway,
That's the highest it's been, and then, I can email this to you, cause it goes all the way to 2014.
or there are a bunch of breakdowns on it?
Yeah, like I said,
Could
it
you
wasn't
just email
one-
me that? That'd be
Yeah.
great, yeah. And in fact, I'll make a
So what is
copy
it
of it and give it
right
to the
now?
students
Right
next time I
now?
teach it, so.
If you signed a lease between January 1st of 2014 through December 31st of 2014, it's 0.17%.
Okay.
Boy, that's still 3 times what the bank's gonna give you.
Yeah,
Wow.
that's true.
So I'll
Huh.
email this to you and then, well, I don't know what your
That's
email address
interesting.
is.
Yeah, my email address is
Would you say
Jim at, you guys will write this down too if you want to get a hold of me, it's Jim at AmericanRealEstateCollege.com.
Do you want it to?
Jim at, I prefer, if you could text it to me, I get 200 emails a day, probably like you guys do too. So if you can text it to me, I definitely will get it if you need to contact me that way. But again, Jim at AmericanRealEstateCollege.com. Okay.
0.17? Yeah.
Well, that's interesting.
Cool.
Okay, let's keep going. Let's go to page 21-12 and talks about leases again. And we talk about this so many times in this course. Let's talk about it again. And the introduction, leases. When I'm leasing a property, am I purchasing anything? What do you think?
Yes.
Right to claim, isn't it?
I'm purchasing a right of possession, right? But it's a reversionary right that after the lease ends, it's going to go back to the owner. But I'm purchasing a right of possession, and I'm also purchasing an implied right of quiet enjoyment, where I can keep the landlord out. That's only an implied right, because you can eliminate that and let the landlord in if you want to. But we have a definitive right of possession that we're purchasing in a lease, and an implied right of quiet enjoyment, we can keep the landlord out. So let's read this. Introduction. That second paragraph there on page 2112. A lease is both a contract and a conveyance. It sets forth the terms of the agreement between the parties, landlord and tenant, lessor and lessee, whereby the rights to possess and use the property for a certain period of time is transferred from one to the other. The interest of the property transferred may be nominal, such as a lease for 1 month, or it may be very substantial, like a 99-year lease. A lease for 1 year or less may be oral. A lease for longer than 1 year is required to be in writing to be enforceable under the statute of frauds. We talk about that many times in this course. And a written lease is always preferable because it furnishes objective proof of the terms agreed to by the parties. A lease is an agreement between the lessor and the lessee, landlord and tenant typically, whereby the lessee takes possession and receives the use and profits of an estate and real property for a certain period of time, in return for which the lessor receives the lessee's performance and payment according to the conditions of the agreement. And we have these different types of leases. The first one, of course, is a tenancy for years. That's an actual lease. It has a definite beginning, definite ending period, definite ending time. So it has a definite window that we're purchasing in a tenancy for years. And that's what a lease is. Another word for a lease is tenancy for years. What if I have a 1-year lease on this property, and halfway through it the landlord sells the property? What happens to my lease? Nothing happens to it. The person who buys it has to honor my lease, and they can't come in and raise my rents unless in a lease we have what's called a sales clause. Okay, let's back up. Remember the power of sale clause? Tell me about the power of sale clause. What's that about? Remember that yesterday or the last session?
It's to bypass court, right?
Bypass
The court.
the courts. Yeah, that's for the public trustee to bypass the courts and start a foreclosure sale. That's a power of sale clause. This is a sales clause. Two different things, completely different things. This sales clause would be in your lease. See, every landlord wants a sales clause, where they say, if I sell my property, then the new guy coming in buying the property can go in and renegotiate the leases. It makes your property more valuable if within your leases you have a sales clause. So the landlord wants the sales clause, the tenant doesn't want the sales clause. And most tenants, of course, have no clue what they're even signing when they sign a lease. And there are no approved forms for leases for the state of Colorado. You can do a lease on the back of a Safeway bag if you want to. And you can put anything in there at all, as long as it's legal, as long as it's legal. I got a call from the Louisville Police Department a couple of years ago, a few years back anyway. And they said, we've got this couple in here and we really have a problem. The landlord has been in their property 3 times at 1:30 in the morning inspecting the place.
What?
And so he said, and we don't know how to really handle it. We called up a couple attorneys and they don't know, and I said, well, do you have the lease there? And they said, yeah. And I said, what does it say about does it say anything about quiet enjoyment? And they said, yeah, right here. And I said, what does it say? And it says the landlord can inspect the property at any time without notice at his discretion. And the people signed it. So he can go in there in the middle of the night, 1:30, 3 o'clock in the morning if he wants to. You know, and the people agreed to it. You know, if they're doing that in my place, he better be wearing a vest. You know, and again,
Well, you read your contracts before you sign anything.
yeah, exactly.
9 times out of 10, people just like take a pen and they'll just sign it. They don't care. They want to get in.
Exactly right. And again,
You don't think about that stuff when you doing a lease. Like quiet enjoyment, who would know about that term unless they're in real estate?
exactly.
You
Now
have
you
an
guys
attorney look
know.
at your rental leases always before you sign it.
What's
There's
that
so
now?
many hidden, you need to have your attorney look at your rental leases.
Oh, man.
There's so many hidden. I worked for Denver Property Management, and you are going to get screwed by that company, bar none. Seriously, it's awful.
I'm recording.
I'm not licensed. Not yet.
Yeah,
I'll say that.
okay.
I'm happy to say that. They have so many DORA complaints. Go ahead.
Really? Yeah.
Yes.
And again, guys, you can give up that right of quiet enjoyment by letting the landlord in. I had another student a couple years ago, young lady, you know, in her early 20s, 21, 22, 23, something like that. And she said she and her roommates, the landlord comes in and just sacks out on their couch a weekend every month.
What?
And I said, do you want him in there? And they said, no, we don't want him in there. I said, well, kick him out. He has no right to be in there unless you give him that right. So again, that's we have a definitive right of habitability, possession. We have an implied right of quiet enjoyment, keeping the landlord out. Okay, so we have this tenancy for years. I have a 1-year lease on this property. How much notice do I have to give? None. It just ends. It's a 1-year lease. It just ends. Now, how do most tenancies for years work? It's a 6-month lease, and then it rolls into month to month. Okay, that 6-month lease is just that. It's a lease. When it turns into a month to month, it becomes not a lease at that point, but a periodic tenancy. See that last paragraph there? Where you don't have a definite ending period. So again, tenancy for years is the actual lease, then it rolls over into month to month, or tenancy from period to period, or periodic tenancy, same thing. And then on top of page 2113, we have tenancy at will. And that's where you have a buddy of yours staying in your basement or something. You're probably not going to have a lease. And you're just being a nice guy helping somebody. A tenancy at will. And the main thing about a tenancy at will is 3-day notice of eviction. A 3-day notice of eviction. Boy, write that down, guys. Guaranteed question on the state exam. Smile when you see it. 3-day notice of eviction. Tenancy at will. And so you're not going to have a lease typically on a tenancy at will. And that's why the statute of frauds says that for a lease for a year or less can be verbal, just to accommodate tenancy at will. And then we have tenancy at sufferance. You'll hear it called an estate at sufferance, and it's not an estate. Tenancy at sufferance or a holdover tenant. I lease my property out and my property goes into foreclosure, the new owner comes into my property after the foreclosure sale, and there's, the renter's still in there. They're holdover tenants. They're tenants at sufferance. They're in there against the wishes of the owner. And then we have things about types of leases, like a ground lease. Let's read this. Tricky question on the state exam about this. Let's read this. A ground lease is a tenancy for years whereby a parcel of unimproved land is let for a typical standard period of time. Let means leased. Some of you remember the song Trailers for Sale or Rent? Rooms to Let, 50 cents. I'm dating myself. But Roger Miller sang that. Killer song if you haven't heard it. But that's where the word let came from, pretty much. That was popular back then. So let means to rent something. It's let for a typically extended period of time. It's a ground lease. And this usually allows a building to be erected on the land by the tenant and provides for the disposition of the building at the end of the lease. So I build my $1 million house on this property I'm leasing. What happens to my $1 million house at the end of the lease?
Goes to the landowner.
What does the lease say? Okay, so let's keep reading here. The landlord may become entitled to the building upon the payment of all, part, or none of the value of the building, depending on the agreement. I didn't have an extension clause or a renewal clause in my lease. And in the absence of an agreement, the building legally becomes real property and belongs to the landlord, who is not required to reimburse the tenant. Isn't that something? And you're going to have that question on the state exam. A house built on leased property, at the end of that lease, becomes, and they'll say, the personal property of the tenant, the personal property of the landlord, the real property of the landlord, with or without payment. That's the answer. That's the answer. Whoever owns the land controls the people.
I have that situation in Bali because you can't buy property in Bali unless you're Balinese or Indonesian.
Oh.
And so you do like a rental agreement with friends, or, you find someone you trust because they can totally screw you over. And then I just built a little palapa bungalow, and I have like a 30-year. But the cost of the improvements was next to nothing.
Cool, cool. And you'll see this, like, in Mexico, you have to be a national to buy it. And most countries, not anymore. Really?
It depends on how close you are to the border. If
Really?
you're within 50 kilometers, I think, of the coast or the border, then you have to buy in Mexico using a trust, a
Fideicomiso.
So that you're working it that way then. Okay.
So then the bank owns it, and you control what the bank does with the property, and it's
Yeah.
trust.
But most countries in the world, you're limited on what you can do, except for the United States. Anybody can buy property here for any reason, just like we can. So, there's a class that the boards put on, the Colorado Association of Realtors, and it's a class they teach about customs of these other countries. And you actually go on a list where if anybody from Germany or Italy or where Bali, whatever, they're coming here, then they'll give them a copy of this list so they can call you and have you find them properties here. Pretty cool class. It's only a couple, 3 weeks long. Like I say, and it's through the Colorado Association of Realtors, through one of the boards. And you get this certification and this title after you complete this course. And it's going to get you some business you wouldn't
What's
have
it
any other
called?
way. I don't know what the name of the course is. I hate to start talking about it because I can never, it's a weird name. But just describe it. They'll tell you exactly what it is. Because you're going to join one of the local boards. Remember, there's 6 boards in Metro Denver, then the Boulder board. So there's 7 boards altogether. And once you belong to one of them, you have access to all 7 of them. So you have access to like 4.5 million people just by joining one of those boards. Pretty cool. Pretty cool. So that's how it works in Colorado. And these boards we have in Colorado are exceptional. They do a tremendous job for us. Okay. So this ground lease can be long-term. Let's look at the last paragraph here on page 2113. The long-term ground lease holds another advantage for an owner of valuable land lacking sufficient finances to develop it. An owner may introduce a tenant to make suitable improvements by means of rent concessions. With appropriate improvements, the fee holder's land will increase in value, and the increase benefiting the owner at the end of the lease. Such leases often provide for the increases in value to be matched by increased ground rent at certain intervals. This is what is known as a step-up lease or graduated lease. Let's talk about this graduated lease, because there's a question on the state exam coming at you. And a graduated lease is like a grand opening special, where you want to get people in there, so they drop it down low and they'll increase it as more tenants move in. A graduated lease, remember that, like a grand opening special in this retail area or apartment or whatever.
That's what they did at Union Station downtown when they opened it.
Oh,
'Cause
man.
They couldn't
They
get
did, I heard
tenants, so they offered them killer deals for the first couple of years.
Do they have to disclose when you're signing those leases that they're doing a step-up lease, or that it could?
Oh, yeah.
Yeah, they have to disclose that.
Oh, yeah, it has to be disclosed and what that's gonna be and everything. Yeah, Union Station, amazing what they've done to that,
Yeah.
just incredible.
So
Okay.
what is the question gonna be on the?
And so
with the
a
step-up
graduated lease is like a grand opening special, where it starts out low and it increases as more tenants move in. That's exactly what the answer is. And well, you'll have it on your finals too, here, so you'll have that question. You'll be ready for it on the state exam.
Commercial property? Are you talking about commercial property?
Any
Any
property,
lease.
Oh, okay.
any property, commercial or residential or retail or anything, yeah. Again, a graduated lease. Look on percentage leases. Percentage leases, another tricky question on the state exam. Let's read this, then we'll talk about it. Percentage leases are used for commercial establishments, generally retail stores, and usually provide for a fixed minimum rent plus a percentage of the tenant's gross sales. Gross sales or gross income must be clearly defined and should provide for such things as return merchandise, discounts for prop payment made to customers, sales to employees, mail order sales, services rendered at cost such as clothing alterations, and income from vending machines. Detailed provisions should be made concerning the tenant's records and the landlord's right to examine or audit the tenant's books. Satisfactory use of percentage leases require thorough knowledge and expert judgment. So, question on the state exam says we have a set amount plus a percentage of the sales. And that's what we use for retail. That's exactly how shopping centers work, or any retail establishment who's renting. They have a percentage lease. It's a set amount plus a percentage of their gross sales. And the answer is this is known as and A is a gross lease. And you think, well, it's based on gross sales, it must be a gross lease. No, it's a percentage lease. Don't miss that question, guys. It's based on a percentage of your sales. Okay, of your gross sales. It's a percentage lease. And another question like in the state exam, an example of a percentage lease would be a art gallery. They like that question. Remember that art gallery. And then we have sky leases, which are very rare around here anyway. Back east you see them, like in Chicago. All of the tramways in Chicago, from the way I understand it, is above leased properties. They actually have to pay a lease to go over these people's properties. They actually are leasing that airspace above the properties there. You go downtown, Holy Ghost Church, downtown Denver, actually it's built over the skyscraper. Or excuse me, the skyscraper is built over the church, and I don't know if they purchased it or leased it from Holy Ghost Church. But Holy Ghost Church made out real well with that, no doubt. And that again is a sky lease. And then you have net leases, bottom of the page, and you could have a single, double, or triple net lease. I have a set amount, plus I pay the utilities. Net lease. I have a set amount, I pay the utilities and upkeep. Net lease. I have a set amount, I pay the utilities, upkeep, and taxes. That's a triple net lease, or net lease. And you'll see those in commercial and residential. Again, a net lease. Boy, know the types of leases really well, guys. Know these well. And also for real life, and for your own good too. You know, most of us aren't gonna be renting again, but our kids are, our grandkids are. And it's important that we know how to protect them when it comes to this kind of information. And then on top of page 2115, second paragraph talks about a gross lease. A gross lease is a set amount. The difference between a gross lease and a net lease is a net lease subsidizes the owner's expenses. It subsidizes the owner's expenses. Where a gross lease is a set amount, it doesn't go up. Question on the state exam says, what type of lease does a tenant want in an inflationary period? A gross lease, because it's a set amount every month. And then we have a farm lease. You're not going to really see anything about this. That's like a sharecropper. He uses his crops essentially to pay his lease. Just remember what it is, just in case. Again, a farm lease, agricultural lease, they may call it. And again, it's a crop sharing type of thing. Then we have the elements of a lease, same thing as the elements of a contract, the elements of a deed of trust, elements of a deed, and the same thing. Once you know one, you know them all, with a few little changes. We have to have the date, which is just a benchmark. We have to have the parties, and consideration, of course, is what? Something of value, a description of the property. We have to have words of conveyance. On the side of that, put down intent. We have to show an intent to convey. Conditions and exceptions. I'm renting you my property, but I want to keep using the garage for my own use to store stuff, something like that. You can do that. Lessor and lessee's covenants, any promises that you make with each other. And the signatures. Let's read this. A signature for longer than 1 year must be in writing and signed by the parties. The best evidence of the parties' mutual assent is a signed instrument. If a lessee takes possession without signing, only the lessor needs sign to create a valid lease. The lessee's taken possession is evidence of his or her assent to the lease. So the tenant doesn't have to sign the lease. If they take possession, they're accepting all the terms of that lease. And a lease, a seal, we don't use seals in Colorado.
You mean a notary or?
Yeah, just anything, just any type of
What's
seal.
the other word for notary? Legal word?
Acknowledgement.
Acknowledgement. Right.
Yeah, we really don't have seals in Colorado. And delivery, like a deed, a lease must be delivered to be effective. You have to have delivery and acceptance. And recording, we don't record leases in Colorado either. In fact, that could be a dangerous thing to do. You could encumber that property and cause damage to the owner. The only time I would record a lease is if I had a rent with option and I have 1 year to exercise my option. I might record that lease, but even then I'm taking a real chance doing that because I'm encumbering that property. But I want to encumber it so they don't sell it out from underneath me. So that's the only time I would record. And then acknowledgement, again, would be a notary. Lead-based paint disclosure. Yes, you have to have lead-based paint disclosure on leases, too. And for that, again, for any property that had a building permit before January 1st,
Does it have to be
1978.
signed before the contract?
Yes.
Yeah.
You know, on a lease, yeah, it still has to be signed before any contract. Yeah. Or that contract is void. Look at number 14. Any city or county regulation on occupancy. Let's read this. Some other lease clauses that may apply include cost of living adjustment, handling of the security deposits, use of the premises, acceptance of the premises by the lessee, surrender of the premises at the end of the term, maintenance, repair, and alterations of premises during the term, responsibility for payment of utilities, personal and real property taxes, entry and inspection by lessor's agent, assignment and subletting, agent hold harmless clauses. Landlords and management companies are allowed to have limited hold harmless clauses. What's that word again? remember, exculpatory language, protective language. The only ones who can have a limited amount of that are property managers. Repossession due to unpaid rent, abandonment of the premises by the tenant, holdover clause, or the holding over, the estate at sufferance, tenancy at sufferance, holdover tenant, future sale of the premises, cessation of lease by condemnation or destruction of the premises, right of the lessor to mortgage or subordinate and sign regulations, renewal options, termination notices, and disposition of deposits records upon the change of the property managers. And then we have termination of leases. Leases may be terminated in 4 ways: by expiration of the term, by surrender and acceptance, by breach of condition of the lease, and eviction of the tenants, which we'll talk about in a minute here. And then we have the last 2 lines on this page are the ones you have to pay attention to. Month to month, or up to but less than 6 months, you have to give 10 days prior notice, and a tenancy at will, minimum 3-day notice. Now this month to month, I have a 6-month lease, which is an estate for years, then it rolls over to month, and most month to month, they want a 30-day notice, and is that fine? It has to be at least 10 days. So 30 days is pretty typical for moving out, or them getting you out, or you leaving. 30-day notice on month to month. But you have to have a minimum of 10 days. The only one, too, you have to remember is the 10 days on month to month, and a tenancy at will, 3 days, notice of eviction. Okay, why don't we go ahead and take another 10-minute break.